Dear speaker, colleagues that watching us online, my name is Roman Nikolyak. I work as an international relation coordinator at the Center for Civil Liberties, and today I will be moderating our event. You can ask questions in the chat, or after the event you can post them by yourself. Our previous webinars available on CCL YouTube channel, meaning you can revisit them for your educational purposes. Today, we will hear a lecture about cyber operation and international humanitarian law delivered by US academic and military professional, Mr. Captain Christian Fleming. While IHL, international humanitarian law, exists for almost 200 years, the cyber warfare and cyber operation become possible only in the last 2 or 3 decades with the invention of the internet and the use of mass media. Captain Fleming will discuss how international humanitarian law applies to cyber operation during international armed conflict. For example, Russian invasion happening right now is the international armed conflict. He will specifically concentrate on the notion of attack in cyberspace, principle of distinction, who and what may be targeted for attack by cyber operation, and the principle of proportionality, precision attack and defense, and the prohibition of the indiscriminate weapons. So he will use classic IHL concepts which are relevant starting from the Great War, from the First World War, and he will apply these core principles and core ideas to operation in the cyberspace. Captain Fleming is a senior military instructor at the United States Defense Institute of International Studies, and also he is an Adjunct instructor at Center for Global Affairs in New York University. He is indeed a captain of US Navy, assigned as a senior military instructor with the Defense Institute for International Studies, where he specialized in cyber warfare, meaning Captain Fleming is best suited, best speaker for our today's webinar, because he combines advanced academic experience together with military service experience. Captain Fleming, the floor is yours, and I see you already shared your PowerPoint presentation. Thank you for being here today with us.
Thank you very much, Roman. It's a great honor and a privilege to be able to talk with you today, and I appreciate your introduction. We're really going to be taking what I say is a 30,000-foot view of cyber operations and international humanitarian law. It's like we're flying over in an airplane and we're looking down. Because of the time limitations we have, we can only do a real quick review of how IHL applies to cyber operations. And I just want to make certain that we're all on the same page. In the military, my military background, we usually talk about the law of armed conflict. Marines like to call it the law of war because that's what Marines do, right? They're fighters. Academics and my European colleagues usually refer to it as IHL, International Humanitarian Law, but we're all discussing the same concepts, the principles of distinction, the principles of the prohibition on unnecessary suffering, the conduct, the laws that regulate the conduct of hostilities during international armed conflict. So how do we know that this body of law applies to cyber operations? And as you said, Roman, in your introduction, this is a relatively new body of law as applied to cyber operations. And really, it has its genesis in the cyber operations conducted against Estonia in 2007. So just like Ukraine, Estonia at one part was part of the Soviet Union. And throughout history, Estonia was an independent country, and sometimes due to its location, was brought into different empires throughout history. And after World War II, They were an independent country between World War I and World War II. After World War II, they were brought into the Soviet Union. And they regained their independence as the Soviet Union fell apart, just like Ukraine did. In 2007, there was this a monument. It was called the Bronze Soldier. There was a monument to the liberating Soviet army that was in Tallinn, in the capital, in sort of a main area of Tallinn. And there were a large ethnic population of Russians who had moved into Estonia during their occupation by the Soviet Union. And the president of Estonia said that they wanted to move this bronze soldier, this monument to the Soviet army. The Russians saw this as a monument to their uncles and their fathers who had fought in the Great War. But the Estonians saw this as a monument to the occupation that led to their occupation by the Soviet Union. And so the Estonian government published that they were going to move this bronze soldier, not destroy it, just move it to a Soviet army cemetery on the outskirts of Tallinn. There was a lot of misinformation that was put out in the Russian press. There were rumors that the Estonian government intended to destroy the statue, melt it down. And there were physical riots that broke out. And in conjunction with these physical riots, breaking windows, people getting beat up, there were cyber operations being launched, distributed denial of service operations, DDoS operations. And we have to put this into context, that Estonia, very, very wired country, very, very high tech. They vote through cyber means. They pay their taxes through cyber means. They do all their banking in cyber means. They park, they pay their parking fees through cyber means. I've hiked out in the middle of the countryside and seen signs saying Wi-Fi that way when I was in Estonia. So it's very, very wired country. And these DDoS operations, these distributed denial of service operations, really brought the country to a standstill for 30 days. There was no banking that was going on. Companies couldn't conduct business. The government couldn't conduct their government business. So Estonia was brought to a standstill. And these operations were linked to Russians living inside of Estonia, linked to Russians living inside of Russia, but they were really coming from all over the world. And Estonia, as a member of NATO, turned to Brussels and said, we believe we might be under armed cyber attack. And no one really knew what the answer was. Was this the equivalent of an armed attack, these cyber operations being conducted inside of Estonia that brought their country to a standstill? And so after this crisis passed, Estonia said, we have to get smart on the law. We have to, form the Cooperative Center of Excellence inside of Tallinn, which was a specialty for cyber defense operations through NATO. And then they started a project called the Tallinn Manual. And they got together a group of experts that worked in Tallinn for a few years. And they studied this issue. What is an armed attack in cyber? What is a cyber attack? And the outcome was the publication of this book called the Tallinn Manual on the International Law Applicable to Cyber Warfare. Now, this was not law. This was a group of experts that stated what their view of the law was. This was not a NATO publication. This was put out by a British university. And it's up to states under international law. It's up to states to create the law and to say what the law is. And soon thereafter, the UN got together with a group of governmental experts provided by different states, member parties to the United Nations, and they started thinking these issues through. And over time, states have made proclamations on what they believe the law to be. Tallinn Manual 2.0 came out, and this really expands from warfare to cyber operations during peacetime as well. So both the international law of cyber operations conducted during armed conflict, as well as the peacetime framework. And the Dutch really have taken a lead in going around and training military and government personnel from other states on this body of law, the international law of cyber operations. And states continue to make statements on what they believe the law to be, because it's states, like I said, that create international law and define what the law is as it relates to cyber operations. Just this morning, I was reading the country of Ireland put out their statement on what they believe the international law of cyber operations is. And they talked about how cyber operations can violate sovereignty and the due diligence obligation in cyberspace. So it's states that make international law, and states that say what the permutation as it applies to cyber operations should be. So for purposes of this talk, we're going to be focusing on cyber operations conducted during international armed conflict. The first question of any international legal analysis is always, are we in an armed conflict? And as we know, Ukraine and Russia are in an armed conflict. The second question is then, if you're in an armed conflict, is it international or non-international in nature? And of course, the current conflict is an international armed conflict. So we're going to look at how IHL applies to cyber operations, especially in the context of the full-scale invasion that's occurring right now. So as we know, there are really two fundamental principles under international humanitarian law. There's the principle of distinction that states that at all times the parties to the conflict must differentiate between civilians on one hand and combatants, and civilian objects and military objectives, and only target military objectives with attacks. This principle of distinction gives rise to other concepts such as the rule of proportionality, where even if a civilian object is not specifically targeted, if the damage to civilian objects and the injury and death to civilians is excessive to the concrete military advantage to be gained by the operation, it's still prohibited. Indiscriminate means and methods of warfare are prohibited. And this is particularly relevant to cyber because a malware once launched, as we saw with NotPetya, can hit targets indiscriminately. And there are several precautions in attack and as well precautions in defense that must occur. The other cardinal rule is the prohibition of superfluous injury and unnecessary suffering. And as we talk during the next hour or so, we're going to be discussing how these cardinal rules of IHL apply to cyber operations. But first, we must analyze what is an attack when conducted by cyber means, because it's attacks that are specifically regulated under IHL. You can have a psychological operation against civilians. That's been done throughout history. So a cyber operation that doesn't rise to the level of attack can probably be conducted against civilians. So misinformation campaigns, say, during an international armed conflict would not be prohibited per se. Espionage, if you have one military hacking into the computer network of another military, that would not be prohibited per se under IHL. So we have to look at what the concept of the notion of attack is. And when we look at cyber, when we have a cyber operation, what we're sending ones and zeros through cyberspace, that in itself is not violent, but we have to look at the effects of that cyber operation, the consequences. So if we have a cyber operation launched against a military aircraft, say, that manipulates the data, the GPS, the coordinating data for flying this aircraft, such that it can tell where it is, and that data is manipulated and the aircraft winds up crashing into a mountainside, that's a violent consequence of that cyber operation. So that would be deemed to be a cyber attack. So we're not just looking at the operation itself, but the expected, the intended effects of the cyber operation. So when we look at a cyber attack, the way to define a cyber attack is a cyber operation, whether taken offensively or defensively, that's reasonably expected to cause injury or death to persons or damage or destruction to objects. So that comes from the Additional Protocol 1, Article 49, definition of what an attack is. Ukraine is a party to Additional Protocol 1. So we look at a cyber attack as causing damage or destruction to objects, death or injury to persons. But what about a loss of functionality caused by a cyber operation? If you have a cyber operation that bricks a computer, bricking meaning making it so that it can't function properly. Think the Shamoon virus, which was reportedly launched by Iran against Saudi Aramco, that wiped out laptops of the Saudi Aramco oil company and caused them not to function properly. Is that an attack when you just have a cyber operation that doesn't physically break something, but causes it not to function as intended? And when we look at the Talon manual, when we look at what the group of experts determined, we saw that they had 4 views. And some of the experts said that just causing a machine not to function properly, just impacting functionality of a computer system wouldn't qualify as an attack. But that was really a minority view. Of course, if there's physical repair that's necessary, that's the equivalent of physical damage, that would probably in all likelihood qualify as damage, so that cyber operation should be deemed to be an attack. But what if it just requires restoration of data or reloading the operating system? Well, some of the experts thought that this too would be deemed damage, such that the cyber operation should qualify as a cyber attack. And we see states that are taking this position. New Zealand has issued a statement saying that a loss of functionality of a computer system should be deemed damage, such that during an international armed conflict, that cyber operation would qualify as a cyber attack. So we see states issuing statements taking this position that a cyber operation that impacts functionality could be deemed to be a cyber attack. Now, a cyber operation also could be integral to a wider operation. So say a cyber operation is conducted that affects power system. So one invading army intends to conduct a military campaign, and they decide to turn off the power system to a military base. That in itself might not cause damage or destruction to persons, but if it's part of a wider operation where besides just turning off the power, the army is going to start dropping bombs and blowing things up, then that cyber operation could be deemed an attack because it's part of that wider operation being conducted. So we have to put our cyber operation in context and look at what the intent is of the operation and all of the reasonably foreseeable effects of the cyber operation. So let's look at some examples here. And I'm happy to throw these questions out to our participants what their thoughts on. But for these scenarios you see up on the screen, let's determine whether these would be deemed to be a cyber attack or not a cyber attack. So let's go with the situation that we are engaged in international armed conflict, and that these cyber operations, these proposed cyber operations, are being conducted by the cyber unit of the armed forces of one of the parties to the international armed conflict. So if you have a cyber operation launched that opens the sluice valves to a dam, and that causes flooding. So a cyber operation opens up the sluice gates on a dam, and water comes pouring out, causing flooding that damages buildings and kills people. What do you think? Is that a cyber attack?
Dear guest in the Zoom, please answer. Otherwise, I will guess, but it will be not nice. Please, if somebody would like to speak up. Okay, this time I will speak up, but next time you. So due to
Olena has her hand raised.
Olena, please unmute yourself.
Well, I think that it is a cyber attack because according to the definition, which is reasonably expected to cause injury or damage to persons, and when the dam is blown up and here kills 5 people, right, and damages the buildings, then according to the classical definition, it should be a cyber attack, or at least considered so, because it already brought the consequences and we know them.
Absolutely. No, great answer. Definitely fits the definition of a cyber attack. And this is not speculative, right? Because we saw the Russians blow up one of your dams, right? And there was an indictment. Actors from Iran tried hacking into a dam in upstate New York State in the United States. Luckily, it was offline at the time, but they were gaining access to the sluice valves on the gate. So this is not speculative. This is something that could actually occur during an international armed conflict. What about if one of the parties to the international armed conflict hacks into the military computer network and they're looking at classified documents, secret documents regarding troop strength? Does that meet the definition of a cyber attack? Hacking in, conducting espionage.
If I may say that if the goal of this attack to gain military advantage over the enemy, this is indeed the cyber attack.
Okay, so I think the way that the press uses the word cyber attack, it would, but for us international attorneys, we define the cyber attack as a cyber operation that's reasonably expected to cause injury or death to persons or damage or destruction to objects. So just conducting the espionage in and of itself would not be deemed to be a cyber attack because it doesn't have that. It's not prohibited to conduct espionage. So this would not be a cyber attack in my view, just the espionage part of it. But a cyber operation that would turn off the early warning system, allowing bombers to penetrate air defenses, that would be, right? So just turning off the early warning system in and of itself would not be deemed a cyber attack. But if it's part of that if it's an integral part of that military operation, allowing the bombers to penetrate air defenses and strike military, that would be deemed an attack. And again, this is not speculative. Israel actually did this called Operation Orchard, where they wound up hacking into Syria's air defense systems, spoofing them to make it look like the Israeli jets were in another location, and then they bombed what was alleged to be a facility for a nuclear power. How about a misinformation campaign on social media? If an invading army starts putting out misinformation on social media, Facebook or whatnot, is that an attack, a cyber attack? And I think we have to say no, that's not a cyber attack. Throughout history, during military campaigns, there's been information operations against civilians to try to degrade the will to fight. So that in and of itself would not be deemed an attack. It would be a cyber operation. And again, the reason that this is significant is because a misinformation campaign would not be prohibited under IHL, even if it's directed against civilians. And that's why we have to say what is an attack and what's not, because if we say that an operation is the equivalent of an attack, then it would be prohibited if it's being targeted at civilians. How about a cyber operation that bricks, meaning causing them not to function properly? 500 laptops used by an oil refinery. It depends on what your definition of an attack is. If your government sees that it defines a loss of functionality as being damage, then it would be. This would be. But if your government says that a cyber operation that impacts functionality does not amount to a cyber attack, then it wouldn't be. So for that example, a cyber operation that bricks 500 laptops, it depends. It depends on your country's definition of what an attack is, whether a loss of functionality would be the equivalent of damage. And that's what states make law, and you know, it's up to Ukraine to say what their view of a loss of functionality during a cyber operation is. How about a distributed denial of service operation against banks blocking online access to accounts by civilians? Again, this is going to depend on your country's definition of what of an attack is, whether loss of functionality defines it. I tend to think that a DDoS operation against banks during an armed conflict would not be tantamount to an attack, but some countries could say it is. A hack into a state bank, illegally transferring 10 million US dollars, probably not an attack, probably not. It could be prohibited by prohibition of plunder or looting under IHL, but probably doesn't rise to the level of an attack. But a hack into pacemakers, turning them off, resulting in death of 10,000 people. That would definitely be an attack, right? You have death to people. Our Vice President, Dick Cheney, had a pacemaker on, and when he was Vice President, and it was put out in the news that there was a vulnerability in pacemakers, that people could hack into them and control the pacemaker and turn them off. And guess what? Vice President Dick Cheney kind of disappeared for about a week or 10 days while he was having that worked on, because he knew that was a vulnerability. So if we're engaged in an international armed conflict and one of the parties creates malware that turns off pacemakers, killing people, that would be deemed an attack. So once we know what an attack is, then we have to apply the principles of international humanitarian law to these cyber operations. One of the key principles is the principle of distinction. So if we have a cyber operation that is tantamount to an attack, it would be prohibited to direct that cyber operation against civilians and civilian objects, because Additional Protocol 1, as well as customary international law, says that at all times during an international armed conflict, the parties must distinguish between combatants and civilians, and military objectives and civilian objects, and only direct their attacks against military objectives. So this really defines what we can target and who we can target through cyber attacks. So let's first look at who we can attack. So the civilian population as a whole, including individual civilians, cannot be the subject of cyber attacks. How do we define what a civilian is? Well, it's a negative definition under IHL. Civilians are those persons who are not members of the armed forces or assimilated to the armed forces, are participants in a levée en masse. Levée en masse is actually a very interesting concept under IHL. I used to not think that would apply much to cyber operations, but given what has happened in Ukraine after the full-scale invasion, it is definitely a cutting-edge concept. A levée en masse is a kind of an ancient concept from the Napoleonic Wars, where you'd have the invading army cross the border into the victim state, and the civilian population would spontaneously rise up, grabbing whatever weapons they can, rush to the border to try to repel the invading army. So, and it gives them time, they're doing so before they have time to organize, before the army has time to react. So it's a spontaneous uprising by the civilian population that engages the enemy attackers. And they're now deemed to be lawful combatants. They're allowed to strike at the enemy under international law, and they're entitled to the benefits, but they're also targetable now. They lose the protection as civilians because they're part of this levée en masse. So the question of cyber is, can you have a cyber levée en masse? Can Ukrainian civilians spontaneously rise up as the Russian army was invading and engage in cyber operations against the invaders spontaneously? And it's a great question. And I think it is applicable if you have a significant portion of the Ukrainian population who are cyber savvy, engaging in spontaneous cyber operations against the Russian army, I think that does qualify as a levée en masse through cyber means. But then they become targetable, but they are lawful combatants at that point. So civilian is that negative definition. Persons who are not member of the armed forces, participants in levée en masse, and the civilian population comprises that whole group of civilians. So you cannot have a cyber attack directed against the civilian population. And what does that mean to make the civilian population or civilians the object of a cyber attack? Well, that means the cyber attack is directed at the civilians or the civilian population. So we're not talking about incidental or collateral damage. We're talking about intending to target civilians and civilian population, and that's prohibited under international law. So when we talk about cyber targeting of persons, there's really two ways to go ahead and think about targeting. There's status-based targeting, and there's conduct-based targeting. Status-based targeting means we're targeting someone based upon who they are, what category we put them in. Members of the armed forces are always targetable during an international armed conflict. So members of the army or one of the parties to the armed conflict can be killed at any time. When they're eating, when they're sleeping in their racks at night, it doesn't matter what they are doing because of their status as being a member of the armed forces. Now, they become protected if they are hors de combat, which means that they're now captured, say, they're a prisoner of war, they're no longer subject to attack. Or they've clearly expressed an intent to surrender, thrown up their hands and their white flags, and they clearly surrender, they're now no longer subject to attack. Or they're out of the fight because they're wounded or otherwise incapacitated. And now we're protected under international humanitarian law. But otherwise, members of the armed forces can, of course, be targeted at any time based upon their status as members of the armed forces. What about a member of an organized armed group? So members of a group that is organized and armed. When we say organized, we mean there's some hierarchy, some persons in charge of the group, and there's a structure showing who's in charge and who has to take orders from who. That's organization. Armed means that they're capable of conducting attacks. So they have malware, or if we're talking about cyber operations, malware or other means of conducting cyber attacks. So if you have an organized armed group, think if Anonymous was armed, they're an online group. I don't think Anonymous fits the definition of organized armed group, but think about a group like Anonymous that is capable, has the ability to undertake cyber attacks. The question is, are they targetable based upon the membership of the group or not? And there are really two views. The US view is that a member of an organized armed group is targetable at any time based upon their membership in that group. So while we were conducting our campaign against Al-Qaeda, the US view was that any member of Al-Qaeda can be targeted at any time during the armed conflict based upon solely their membership in the group. There's a different view, the view of the ICRC, say, that says that only those members of the organized armed group that have a continuous combat function, so the fighters in the group, are targetable at any time based upon their status as members of the group. So, for example, Al-Qaeda, the chef for Al-Qaeda wouldn't be targetable under this view at any time, unless that chef picks up a weapon and starts actually fighting, and then they lose their protections. But the US view is that any member of an organized armed group is targetable for attack at any time. And then there's conduct-based targeting. So ordinarily, civilians are protected from attack. But if they choose to become a party, if they choose to directly participate in hostilities, then they lose the protections for such time as they are participating in the hostilities. And here is the three-step analysis that must be undertaken. Is there a threshold of harm by the civilian's conduct? Meaning, are there actions degrading the capabilities of the enemy? Think a lookout. So if someone is out there, even though acts of espionage are usually not deemed attacks, if you have a lookout, if you have a civilian on a mountainside with binoculars and a radio, and he or she is giving the enemy's troop movements back to military headquarters, that civilians' actions are adversely affecting the military capabilities of the enemy. So that would be deemed direct participation in the hostilities. Or planting a roadside bomb, that's directly participating in hostilities. So there has to be some kind of threshold of harm of the actions of the civilian. Now, this becomes very relevant in cyber. You have civilians who are downloading materials to conduct DDoS operations against the enemy. And if so, does that meet the threshold of harm such that those civilians now lose their protected status and they can be targeted for attack? And then the actions of the civilian, there has to be a causal link to the hostilities. And there's a belligerent nexus. So that's meaning that the actions of the civilian are connected to the armed conflict. So they're not just hacking into a bank, trying to steal money, just a criminal action during armed conflict, but instead they're doing so as part of the armed conflict. There's that nexus. So if a civilian's conduct meets these criteria, if they're directly participating in hostilities, they become targetable. They lose their protections for such time as they're participating in the hostilities. And there's a different view, again, of what that means. So the US view is that if a civilian intends on directly participating in hostilities, and they do so on Monday, and then they do so again on Wednesday, and then they do so again on Friday, they're targetable even for those times where they're not conducting the cyber operations that are degrading the military's capabilities, because we say it's a revolving door. So they lose the protection for the whole time. If there's intelligence, they're going to keep on participating in the hostilities. The ICRC view is that the civilians lose the protections for such time, and only for such time as they're participating in these cyber operations. So when they're coming to or from the place they're conducting these cyber operations, they're targetable. And while they're conducting the cyber operation, they're targetable. But when they're at home and they're sleeping and they're not actively engaged, they once again have the protections of being civilian. So there's two views of for how long a civilian loses the protections when they decide to participate in the hostilities. So let's look at the IT Army of Ukraine. So I'm sure you're familiar with this. Over 200,000 volunteers currently. They've conducted operations against Russian websites and oil companies and news broadcasting. So what's the status? What are the members? If you have a civilian who joins the IT Army, are they civilians who are directly participating in hostilities? Are they now members of an organized armed group? What are they? What do you think they are?
Like non-combatants, for sure.
Well, what if these non-combatants, these civilians, are conducting cyber operations against the Russian army that degrades the capabilities of the Russian armies? Is that not now directly participating in the hostilities such that they lose their protected status? Olena,
please.
Yeah, I would say it depends on how much harm the IT Army of Ukraine does. I mean, if it's just the reverse action, so according to my understanding, that if these attacks that are committed by the members of IT Army of Ukraine, who are definitely non-combatants in this regard, they're just to revert the attacks and, for example, to prevent some attacks of the Russian military on Ukrainian critical infrastructure, then they definitely don't lose their status. of civilians. But if these actions are bringing greater harm to the Russian Federation, and I don't know, already targeting their civilians and could result, bank accounts, we discussed it, it's not cyber attack, but could result in death of injuries. For example, the Russian nuclear power plant or any objects, then I think they lose the status. So it should be upon the harm and upon the attacks they commit. If it's just about blocking websites or putting misinformation, or Ukrainian propaganda on the websites, and uncovering the war and the real facts to the Russian citizens, or it really has the intent to harm.
No, that's a great answer, Elena. And you're right. The question is, do they meet that threshold of harm? If they meet that threshold of harm. So let's say the IT Army starts conducting DDoS operations that affect the supplies for Russian soldiers, that would probably meet that threshold, right? That threshold of harm, and has that causal link and the belligerent nexus. So if there's a DDoS operation against the supply chain or say the trains that are bringing supplies to the front lines, that could meet that threshold of harm. And we just need to think this through for what is the legal status of the IT Army. When a civilian decides to start conducting cyber operations during an armed conflict, we as legal advisors have to think through, okay, what are they now exposing themselves to? Are they directly participating in the hostilities? If so, they can be targeted, right? Those civilians lose their protected status and they can be targeted. Is the IT Army an organized armed group? Are there indicia of organization, and are they capable of conducting cyber attacks? I don't think they rise to that based upon my readings, but they could if they start undertaking cyber operations that amount to cyber attacks, if they have malware that can have those effects. I think the KillNet group in the Cyber Army of Russia do meet more of this classification as being organized armed groups, possibly even groups that are assimilated to the armed forces of Russia, since there seems to be coordination with the Russian military. So members of KillNet, say, or the Cyber Army of Russia can now be targeted by Ukraine. And if they're an organized armed group, they can be targeted at any time, especially if they have that continuous combat function. So when we're conducting cyber targeting, and we ask, okay, who can be targeted, we have to realize that civilians can lose their protected status by actions they undertake. I remember when the Talon Manual first came out, one of the headlines said, NATO says it's okay to bomb teen hackers, which wasn't really, that's the news report of it. It's not true. But if you have, hackers who start engaging in the armed conflict and undertaking acts that degrade the military capabilities of the enemy, they do lose their protected status. And the response can be a cyber operation against them, but could also be dropping a bomb on them or killing them. So we have to think these issues through and look at who is protected when they start engaging in cyber operations that have detrimental effects to the enemy. So we just looked at who can be targeted. Now, what can be targeted? Objects that are not military objectives are protected as civilian objects, but you see on the screen from Additional Protocol 1, as well as customary international law, the definition of a military objective. And it's those objects which by their nature, location, purpose, or use makes an effective contribution to military action, and whose partial destruction, capture, or neutralization in the circumstances offers a definite military advantage. So one of the threshold questions under this definition is data an object? Is data an object? And the experts who wrote the Talon Manual, their take on it was that data doesn't qualify as a military objective. Data, ones and zeros, is not an object. So it can't be defined as a military objective. And that means that you can have a cyber operation that manipulates data, that deletes data, civilian data. if it doesn't meet this, if it can't be deemed to be a protected object, a civilian object. And this was also one of the controversial parts of the Taliban manual when it first came out. But there's been pushback. Some states have been making statements that government essential data should be protected and deemed to be not targetable during an armed conflict. But that's one of the issues when we look at how IHL applies to cyber. This is one of the issues. And I see I only have a few minutes left before we get to the question. Or should we go to the question and answer now, Roman? I see I'm over time with the talk part of it.
You can we can listen more. You can finish your lecture. We have time.
Okay. So even when a cyber operation does not specifically target a civilian object, if a cyber operation causes incidental loss of life to civilians or damage to civilian objects, it could still be prohibited if it's excessive. That incidental loss of life or the incidental collateral damage to civilian objects is excessive to the anticipated military advantage to be gained. Now, this is a forward-looking; it's not backwards-looking. So, if a cyber operation is conducted and there's a lot more damage than expected, if it was reasonable to believe that that the cyber operation will comply with the proportionality rule, it would not be an unlawful cyber operation. And the standard here is reasonable. So what does a reasonable military commander believe when he's undertaking or she is undertaking the cyber operation? You have to look at all of the effects of the cyber operation when conducting the proportionality analysis, but you don't take in just annoyance. So if you have a cyber operation and it knocks the internet off for civilians and they can't go onto their Facebook account, that's not damage, that's kind of annoyance to civilians. So that sort of action would be taken into consideration for the proportionality rule. But you look at all the effects. If you turn off power in a town and that turns off power in the hospital and civilians die because they're on life support, you have to take that into account when conducting the cyber operation. And if that civilian loss of life is excessive to the expected and concrete direct military advantage gained, then it'll be unlawful. And indiscriminate cyber attacks are prohibited. And this is very, very relevant. So if you have a cyber operation, if malware is created and it's not controllable, if you cannot direct it at just military objectives, then it's indiscriminate. And this is very possible in when conducting cyber operations. And we see this with, say, NotPetya, how once NotPetya was released into the wild, it was targeted by Russia against Ukraine, but it had effects globally. It was an indiscriminate means of warfare and thus probably unlawful under international law. And we have precautions in attack that must be complied with. So you have to choose the means or methods of warfare that's going to avoid the collateral damage the most. So oftentimes that will be cyber, because the effects of cyber often can be stopped and can be reversed. If you have a cyber operation against a power grid, you can often turn it back on a lot easier than if it's bombed from the air. So oftentimes cyber will be the choice of weapon that complies with IHL precautions requirement the most. You have to suspend or cancel a cyber attack if we learn that the object would breach the proportionality rule, and if capable, you have to give warnings if the circumstances permit. Defenders also have requirements and precautions, and this is difficult because so much of cyber is what we call dual use. Now, dual use is not a legal term of art. But we find the military and civilians using the same computer networks and using the same cables. But there's a requirement under IHL when parties are engaged in an international armed conflict to try to spare their own civilians from the repercussions of cyber operations. So that might be making backups of data or having separate internet systems for the civilian population. and superfluous injury and unnecessary suffering are banned. So let's go back to that pacemaker example. You can have a cyber operation directed at the pacemaker of the head of the enemy's military. So if you learn that the head of the enemy's military has a pacemaker and you create malware that's directed at that pacemaker to turn it off to kill that enemy leader, that's lawful. The enemy leader is a lawful target under IHL, so you can kill him at any time. But if your techies decides to turn off the pacemaker for a moment and then turn it back on and turn it off and turn it back on, and you're causing suffering now. You're not just killing them, but you're causing him or her to suffer, to cause unnecessary pain. That would be unlawful. So you can kill, but you can't cause that unnecessary sufferings through cyber operations. So let's do two case studies now for the very end. So the black energy virus, I'm sure you're all familiar with that. In 2015, so this was after the invasion of Crimea, but before the full-scale invasion, there were power outages that were attributable to Russia that turned off power in Kyiv and other parts of Ukraine for several hours, impacting 250,000 customers. So the first question is, when we do any international legal analysis, did this cyber operation, did black energy occur during an international armed conflict? And the answer is yes, because Crimea was being occupied at the time, so that qualifies as an ongoing international armed conflict between Ukraine and Russia. So then the question is, was it an attack? Do you think turning off the power to this many civilians was a cyber attack? Does it qualify, does it meet the definition of an attack under IHL? Well, we have to look at what the effects were, right? Did people die? Did it turn off? Did it affect hospitals? So you had civilians dying, or even military persons dying. Was there damage that was done? So if this power outage created damage or destruction to objects, or death or injury to persons, yeah, it would qualify as an attack. I didn't read about any deaths caused by the cyber operation, and power was quickly restored, after several hours. But there was this loss of functionality. So it could qualify as an attack by a loss of functionality if you deem functionality to be the equivalent of damage to deem it an attack. So was it a military objective?
It was not, because it was conducted indiscriminately, but under IHL power plants, atomic power, nuclear power plants are distinguished for protection, because their damage can influence immense suffering of civilian population.
Mm-hmm. Right. So I agree with you. I think it was not targeted at a military objective, and I believe it was indiscriminate. So I think the black energy virus did not comply with the requirements of IHL. And how about NotPetya? So again, NotPetya was right before the full-scale invasion, but after the occupation of Crimea. So it did occur during an international conflict. Was it an attack? You had, was there physical damage? I think there was some physical damage, but you also have that loss of functionality, taking down global logistics. So was it targeted against military objectives? Probably not, and it definitely was indiscriminate. So again, just like with black energy, this was probably an unlawful cyber operation that was conducted. So I apologize for going over, and I think, are there some questions there that?
Yes, we have several questions, and Olena, if you wish, you can raise your question by yourself, that one that you post in the chat.
Yeah, exactly. So I don't know if you're well aware of some concept in Ukrainian army, especially in the beginning of a full-scale invasion. So it was like late February, March, the beginning of April. So when the Russian forces were approaching Kyiv and, for example, Sumy and some northern areas of Ukraine, there were some, units, not units, but something that is called territorial defense in Ukraine. And this territorial defense, basically they had weapons which they were given to, but they didn't really have any commandment or leadership, so they were not officially army soldiers. And they were basically civilians that didn't have any proper military preparation, and they just decided to defend their land. In this regard, could we consider this territorial defense as an example of levy en masse? And if yes, for example, if there were, well, we do it hypothetically, yes, if there were any cyber attacks conducted, would it be considered as an attack on civilian population? Thank you.
So that's a great question. And yeah, it sounds like it meets the definition for a levy en masse. So members of a levy en masse are no longer deemed to be civilians. They're now members of the levy en masse, and it's status-based targeting. So they can be, when participants engage in international armed conflict, there are really three things that we're looking at. One, do they have, are they targetable now? Do they lose their protections? So a civilian who now decides to engage in that type of conduct, they become, by their status, members of the levy en masse. They're targetable. They lose their protection as civilians. They're no longer civilians, but they are allowed to engage in the hostilities. So they can kill lawfully and not be prosecuted for it. And two, if they're captured, they become prisoners of war. So they have those protections as well. But they would be targetable if they started engaging in the hostilities as members of a levy en masse.
Thank you.
And another question, are you familiar with Pegasus software and whether use of Pegasus software is cybercrime, cyber attack?
No, I'm sorry, I'm not familiar with that software.
Okay. And second one, NATO Article 5, whether the cyber attack is part of NATO defense strategy. So if the attack is done on one of NATO member states, whether NATO can effectively respond to it with the military power.
So, so NATO's policy is only to engage in defensive cyber operations, although there's been talk about expanding that. But right now, NATO policy is only to engage in defensive cyber operations, although member states can engage in their own offensive cyber operations. Now, whether a cyber operation would result in an armed attack, under the law, we look at are the scales and effects of the cyber operation the equivalent of a kinetic, a traditional armed attack. So if there's a significant, the most severe type of a use of force, so you have damage or destruction to objects, injury or death to persons, that could qualify as an armed attack being conducted by cyber means, and there's no reason to treat a cyber armed attack any differently than a traditional kinetic armed attack. So I do believe that could, speaking in my own personal belief, that could trigger Article 5 if a member of NATO is under a cyber armed attack with severe loss of life through cyber means. There's no reason why Article 5 could not be triggered.
Thank you. And maybe one more question. So it's look like cyber warfare is pretty new part of body of law for armed conflicts, because technologies develop very fast. And here I speak about artificial intelligence and whether AI should be regulated or it should be left to every country by itself, to China, to US, to Great Britain, to use AI for military purposes.
Yeah, so international humanitarian law applies to all means or methods of warfare. So there's something called the Martens Clause. So when the conventions were first being written, there was a fellow by the name of Frederick Martens. He was actually a Russian diplomat. And when they were drafting some of the Hague Conventions, he said that it doesn't matter the means or methods of warfare, even if we don't explicitly state the type of weapon, international humanitarian law will still apply to regulate that type of weapon system. And the International Court of Justice has said the same thing. They had before them the issue of whether nuclear weapons per se were unlawful as a weapon. And the International Court of Justice, looking at the Martens Clause, said that no, nuclear weapons are regulated through IHL. So it doesn't really matter the weapon system, whether you're throwing a rock or firing a machine gun or dropping a bomb or conducting warfare through cyber means and methods. It's all regulated by IHL. So even when we develop new technology, that new technology is still regulated under international humanitarian law. We just have to look at the unique aspects, such as is data an object, or is a loss of functionality damage. So when we have new types of weapons being developed, you look at the unique aspects of those bodies of law, of the unique aspects of the weapon, and apply that to the body of law to come up with the best fit to say whether how that weapon is regulated by international humanitarian law.
Thank you. And maybe the last question, but it is not about cyber attack, it's about killer drone. Whether the use of killer drones are justified under IHL? Yeah,
so just like cyber, drones are regulated, and armed drones are regulated by IHL. So the same rules, if you have a drone that's being used during international armed conflict, you can't use that drone to kill a civilian unless that civilian's directly participating in hostilities, say, and lose their protections. But you cannot kill civilians with drones, just like you couldn't shoot them in the head with a gun. So the same rules apply to killer drones. They're lawful weapons, but they're regulated by IHL. So distinction, proportionality, precautions in attack, etc.
Understood. Thank you. And I will briefly commence the event. Dear listeners, dear speaker, today you participated in Ukrainian Criminal Justice Week, an endeavor organized by the Center for Civil Liberties, Kyiv-based NGO. We are operating from 2007, and last year we received a Nobel Peace Prize together with our American partner, Public International Law Policy Group. We listened Captain Christian Fleming lecture on cyber operation under IHL, and during this week, on Thursday, we will follow up with the crime of aggression, crime of genocide, and other topic of IHL and international criminal justice. Do learn IHL with us, and I hope to see all of you in our other events. Captain Fleming, thank you for your presentation and your moderating question and answer session. It was really interesting. I learned a lot of new stuff.
Thank you very much, Roman, and thank you all the participants. This has been a great honor and my privilege. Thank you very much.
Thank you.
Thank you very much.